No, I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times. I was getting assaulted and tasers and shit. I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
Okay. Court calls case People versus Dwight Miller.
Escalating for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller.
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against you.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
To allege that you committed the crime.
I didn't
of
commit that crime.
resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted resist, or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
Right.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor. If possible, I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to get the discovery? They will have it. I will make it.
Court does call the case People versus Dwight Miller.
Ashley Feltus for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Miller, Your Honor.
He's still muted.
I believe he is orange pants, white shirt, Judge.
I got it.
Oh. I was just happy I could read it.
Thank you for pointing that out. I figured out where he was. Oh, there he is.
This hearing starts
Things
turning
start
chaotic
falling
almost
apart
immediately once the defendant
during this
begins
hearing,
challenging
when
the
the
court's
defendant begins
jurisdiction and
questioning
calling
the court's
himself an
authority
American
and
state
insists
national.
he is an
Instead of
American
focusing on
state
the actual
national.
criminal charge,
Instead of addressing
he
the criminal
repeatedly
charge
demands
itself,
the judge produce
he
an oath
keeps
of
demanding
office,
documents
delegation
from the
of power,
judge,
and even a
including an
surety
oath of
bond.
office,
Meanwhile, the
proof
judge
of
tries to keep
authority,
the hearing
and
grounded
even
in
a
normal
surety
courtroom
bond.
procedure
At the
while
same
defense
time,
counsel clearly
the judge
struggles to
tries to
stop the
keep the hearing
situation from
focused on
spiraling.
normal
What makes
courtroom
this
procedure,
fascinating
while the
is that the
defense
judge
attorney
stays surprisingly
clearly
patient
struggles
at first.
to keep the situation under control. What makes the exchange so interesting is how patient the judge remains in the beginning. He calmly answers several of the defendant's questions, explains where the court's authority comes from, and even warns him not to disrespect his own lawyer. But as the hearing continues, the tension keeps getting worse. Every attempt to move the case forward is interrupted by more constitutional claims, accusations of false arrest, and repeated statements that everyone involved is dishonest. By the time the court starts mentioning possible additional charges, it becomes obvious this hearing is turning into something far more serious than a routine probable cause conference.
Mr. Miller, can you state your name, please?
He may be muted, Judge.
No, he's not muted. Sir, can you state your name?
On and for the record, my name is Dwight Miller. I'm American State National. I'm here to challenge jurisdiction. I'm here on special appearance to challenge jurisdiction, bro.
Can we approach, Your Honor?
Your Honor, I need to challenge jurisdiction.
Okay, how are you intending on doing that?
Well, Your Honor, can you show me your how I'm supposed to do this? See, it's certain things I can't remember because y'all got me in here and I don't have access to the law books. But it's okay.
Are there certain things you want me to show
your
you?
delegation of power, sir?
Pardon?
Can you show me your delegation of power and your oath of
My
office?
delegation of power.
Yeah,
It came from the people of Washtenaw County that elected me. I have a certification of election in back. You want it?
Mr. Miller, as your
I would like
attorney,
a copy of your surety bond, please, and your oath of office.
My surety bond. I don't
Yes.
have one. I'm insured by the county.
So you don't have one? Okay. You don't have a surety bond, huh? So what's your oath?
Mr. Miller, I'd advise not to
swear oath to the Constitution, right? Yes or no?
I'd advise you not to continue this line.
Man, I'm in here. I done got victimized this morning. Are you serious? Can I get a breakout room with my attorney or my so-called attorney?
So-called attorney? No, he's a very good attorney, and he's not a so-called attorney, and you'll not refer to him that way because as you won't be disrespected, neither will he.
Okay, may I speak with the attorney in a breakout room?
You can do that on your own time. He doesn't get a breakout room here because he's live in the courtroom.
Okay. So
what are we doing with his case now that my jurisdiction has been established?
Okay, I'm putting the motion in for dismissal because ain't no so-called witness or victim to sign a sworn affidavit against me.
Please approach, Your Honor.
And not end this? Yeah. Oh. Of course, yes, you may.
So how's y'all having a conversation without me being there?
Okay, we're back to the record in the Dwight Miller case. What I'm going to do, Counsel, you're requesting an adjournment in this matter.
I am, Your Honor. Upon information, believe there may be a new case coming. I understand Mr. Miller booked into the
Your
jail
Honor.
at 10 this morning.
Your Honor.
So I'm asking one day to evaluate.
I object anything she talking about. First and foremost, how is you testifying?
That what?
First and foremost, Your Honor, I want this charge dismissed, man. At no time given, the lady lied.
I know, I heard your motion to dismiss.
Okay,
I denied
listen.
it already.
Listen, Your Honor, under the Constitution, what is it exactly? The maximums of law. If some come from a falsehood, what is that? The first words out this woman's mouth, she lied. She made a story up talking about somebody
Okay,
put a
this
weapon
woman
at her.
is an
Nobody pulled no
assistant
weapon at her because
prosecutor.
nobody
first
had
of
no
all.
weapon.
I believe he's speaking of the complaining witness, but
Oh, the complaining witness. Oh, not Ms.
but Mr. Miller, I would advise you not to say anything more. Given the circumstances, it may be prudent to discuss this matter further and to see, there's a couple other things pending, as well as a potential new charge they're indicating. This might be something we want to set over for a week.
No. I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times. I was getting assaulted and tasers and shit. I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
Okay, but we can't resolve all
I never
that today.
threatened no one. The same people that's making these statements, they all three on felony probation. They done got caught. Their house just got raided. And then they up here playing line up on me.
Okay, so look.
This part of the hearing becomes very important
today
because the judge chooses to slow everything down instead of pushing the case forward while tensions are running high. By this stage, the defendant is loudly claiming he was assaulted, falsely charged, and targeted by witnesses who he says were already on felony probation. Even with all the constant interruptions, the judge keeps bringing the discussion back to procedure, evidence, and courtroom order. The court is now dealing with several problems at the same time. The original resisting and obstructing accusation, possible additional charges, and the defendant's increasingly disruptive behavior during the hearing itself. From the judge's point of view, rushing through all that confusion would only make things worse later on. So rather than turning the hearing into a bigger confrontation, he decides to adjourn the case for a week, leave the bond conditions unchanged, and give both sides time to sort through the allegations properly. That decision likely stopped the hearing from becoming even more chaotic than it already was.
I think the best thing to, so that everybody can try to figure out what's going on, is I'm going to adjourn it out a week rather than 2 weeks. I'll try to expedite it. Let's see if we can get to the bottom of it all. Probable cause conference. Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Bond will continue.
And I should correct my statement, Your Honor, that MAG thing we discussed at the event, I think it's just the court it's going to. I don't know that it's revolving the court. Okay.
Thank you.
So I just got railroaded, huh?
No, that's not railroaded.
Yeah,
I'll let you know when
because I'm not consenting to none of this. The lady,
yeah, cut him. I'm done. I'm so done. Is he gone? Court calls case People versus Dwight Miller.
Yeah, Mr. Miller, it's my understanding Mr. Miller is, Mr. Miller, I don't know what you're showing us, but what would you state your name for the record?
American State National. All my rights have been violated. They can't.
Did you state your name first?
American State National, man. Your Honor, I've been asking for the whole time, man. There ain't no firearm. There never was a firearm. I was kidnapped. My rights was violated. The lady lied on the scene. She said she called the police, said somebody pointed a firearm at her. Then when the police came on the scene, she made that statement again. And then it was proven, the cameras proved none of that happened.
If you want to try to overtalk me, you can. It's not going to work.
Dwight,
it's not the time for you to try to litigate your case.
Where's the firearm?
Dwight, just listen. I was just appointed yesterday. Mr. Gaddy gave me the discovery this morning. Why don't we ask for a 2-week adjournment and you and I can talk?
Where's the firearm? Where's the so-called person that's the victim that signed the sworn
affidavit? Any objection from the people?
No, Your Honor.
Probable cause conference will be adjourned.
I object. I object. I don't get
objections noted and denied.
You violate my constitutional rights.
2025.
I ain't about to write you up. I'm about to send up a judicial review.
And you know what? So let's do it this way. That hearing will be in person. So if you got something to say, you can come right here and say in person.
My back messed up.
Thank you. Mute him.
You know my back messed up.
You're welcome. Court does call the case People versus Dwight Miller.
For the people.
Good afternoon, Your Honor. Rob J. Kilwald calling outside Judge Slay's courtroom. Good afternoon, Your Honor. Dwight, would you state your name for the record?
I'm American State National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. My all my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the
Okay,
record.
first of all, I'm going to
the record.
stop this. I directed this defendant to be in this courthouse in
I got a
person,
bad back, sir.
and he is
I
not
got-
here in person.
Sir, I got
I
a
am
bad
not going to
back.
sit here
I
and
got a
listen to
medical
him
issue.
ramble on and on about everything.
Oh, really?
I don't
So you
mind
gonna
hearing
violate
from
my
people, but I
constitutional
tell
rights?
you, if you're
You
going
gonna
to
violate
say
my
it all, you're
constitutional
going to
rights?
say it to my face. Bench
You gonna
warrant will
violate
issue
my
for defendant's
constitutional
failure
rights?
to appear. No
I
bond.
am here.
We'll get
I
him
can't.
here.
I got a
Thank
medical
you.
issue.
You
So
can
gonna
mute
violate
him.
my
Thank you,
constitution-
Mr. Kilowatt.
Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr.
Bye.
Kilowatt. Court does call the case. People versus Gary Coward.
Good afternoon,
I
Your
know
Honor.
this. Hey, Simpson, I'm coming to see you, bro. You violated my constitutional rights. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems. Get that number. Yeah, I bet you it did log out. Get that number. It will have the full number. We'll go find him. Get the detective bureau on that, please. All right, let's go.
By the end of this hearing, the tension inside the courtroom reaches a breaking point. What started with arguments about jurisdiction and constitutional rights suddenly shifts into something much more serious when a defendant makes statements the judge views as a possible threat. The atmosphere changes immediately after that moment. Throughout the hearing, the defendant repeatedly claimed he was being set up, falsely arrested, and stripped of his constitutional protections. Meanwhile, the judge stayed focused on courtroom procedure, legal requirements, and keeping the hearing under control. Even when the defendant became disruptive and argumentative, the judge continued trying to handle the situation through standard legal process rather than turning it into a personal confrontation. But the final outburst completely changes the direction of the hearing. As soon as the judge hears language that could be seen as threatening, he orders court staff to preserve the phone number connected to the call and directs investigators to get involved. That moment is a clear reminder of how fast courtroom behavior itself can lead to even more serious legal trouble. If this courtroom confrontation shocked you as much as it shocked us, make sure to leave a like, share your thoughts in the comments, and subscribe for more unbelievable courtroom breakdowns.